Good afternoon, everyone. My name is Melissa Andre. I'm the Executive Director of the Philadelphia Tax Review Board. And today is Tuesday, January 23rd of 2024. It is approximately 2:11 and we are convening a session of the Tax Review Board. Today's category is license and inspections. Please be aware that this is a public hearing and it is being recorded. Because the meeting is public, participants and viewers have no expectation of privacy. And by continuing to be in this meeting, you are consenting to being recorded. At this time, we only have one case on the docket, so I'm just going to give control to our chair, Paula Weiss, and proceed.
Okay, good afternoon, everyone. We are here today for the case of L.T. Woods, 1848 East Russell Street. And just a little bit of housekeeping. I note that our docket actually has two docket matters for this petitioner in error. I think we are here, as Ms. Andre stated, for the specific case involving a demolition, and that bill, and that is for the docket ending in 9304, and that we're going to be limiting our discussion to that specific appeal. This board did have a hearing on this matter earlier, and we are here today. I don't know, Melissa, what was the date of that hearing?
Oh, goodness. The date of that hearing was 10/4, so October 4th of 2022.
22. It was appealed to the Court of Common Pleas and has been remanded in part. And I just want to read that partial remand language into our record so that we can then frame how our hearing is going to be structured today. And that this matter was remanded for further expedited evidentiary hearings to be conducted before the Tax Review Board to reassess principal costs of emergency abatement demolition work that had been performed after catastrophic fire and partial collapse of appellant structures at the property located at 1848 East Russell Street, Philadelphia, PA, also referenced as 1848 East Russell Rye, and the originally resulting discounts that the Tax Review Board had provided to appellant. So our reading of this remand is that today we are here solely for the purpose of discussing and taking evidence as to the cost. The validity of the demolition has been decided. The city's actions have been decided. The asbestos matter has been set aside. So what we really want to do is just take evidence today, hear testimony, whatever either party would like to introduce regarding the reasonableness and appropriateness of the cost for that emergency demolition. And I think at this point today, we want to start with the city's presentation, and I'd like the city's representatives to identify themselves for us, please.
Yes, this is Michael Rullo, R-U-L-L-O, on behalf of the city of Philadelphia. And I do have, at the moment, I believe that the only witness that I will be calling is Mr. Stephen Gallagher.
Okay, Mr. Gallagher, could you turn your camera on, please? Good afternoon.
Good afternoon. How are you today?
Good. Could you identify yourself and your position with the city, please?
My name is Stephen Gallagher, S-T-E-P-H-E-N. Last name Gallagher, G-A-L-L-A-G-H-E-R. I'm the Director of Emergency Services and Contractual Services. I manage the unit.
And do you swear or affirm the testimony you're about to give today before the Tax Review Board will be the truth?
I do.
Thank you. Mr. Rullo.
Thank you. I just, for the purposes of the record, I do have a Supervisor Thomas Rybakowski here. At present, it is not my expectation that his testimony will be necessary. But just since he is on the call right now, I did want to at least mention that for the record. And yeah, I just wanted to make sure that was mentioned for the record.
Okay.
And I know everyone likes seeing Supervisor Rybakowski, so at least we do have that pleasure.
Good afternoon, Mr. Rybakowski. So can we just preliminarily get all the numbers again on the record? What's in dispute here?
Sure. 1848
Wait a
East.
minute.
I'm sorry.
Ms. Mitchell?
Yes, ma'am.
All right, we need to swear you in. Could you identify yourself and your position?
Sure. My name is Lashika Mitchell. I am a code administrator for license and inspection.
Do you swear or affirm the testimony you're about to give before the Tax Review Board will be the truth?
Yes, ma'am.
Thank you. Okay.
Okay.
Yep. Proceed.
Okay, 1848 East Russell Street. This is CSU demo. Bill date 11/9/2018. I'm sorry, docket number ended 9304. Bill number 02660385. Principal amount $69,777. Admin charge $14,653.17. Interest $19,418.90. A total of $103,100, I'm sorry, $849.07.
Could you repeat that, please?
I'm sorry, $103,849.07.
Thank you.
All right.
Okay. Thank
And if I may, just for the record, because I don't think it was stated yet, but the board's determination when this was originally heard reduced the principal amount by 20% and abated 50% of the interest. That was not appealed by the city. So as it stands, it is still at present 20% at 20,000 of the principal remains reduced and 50% of the interest remains abated.
All right, so let's get those numbers then. What the current amount do?
Okay, just give me a second, just to do the calculations here. You said 50% of the interest, sorry.
Yes, and I'm reading from the final page of the board's findings of fact and conclusions of law, just for the record. And the direct quote that I'm reading is the decision of the Tax Review Board to reduce the principal amount by $20,000 and abate 50% of the interest.
Okay, I'm sorry, I'm just trying to do the math here.
$709, interest 44.
That's what I got,
777. Okay.
You have it?
No, I do not. I'm doing the interest now.
Let's see, administrative.
Okay, I must not be the best mathematician. I'm just going by Eileen notes that she didn't have that. I'm so sorry
Just
here.
half, whatever. Was it half of $19,418?
That's 9,709.
9,709.
Half the 20,000 off the 69,777 is 49,777.
Thank you. Okay.
Mr. Rulo, for the record clarification, is the reduction of the principal going to affect the administrative charges?
I am staring blankly right now because
We asked the same question.
I am just reading what the decision of the board was, so I'm hesitant to
Okay, well,
provide.
I am under the assumption that, the administrative cost is a certain percent.
21%.
Yeah, 21%, because I was gonna say 20 of the principal. So that's something to think about as well, I guess.
So that would be my assumption that the administrative charge would be reduced based on what the principal amount. But anyway, okay. So that's the decision that was made in October of 2022. We want to move ahead now and focus on, again, the cost for the demolition, the basis for it, how it was derived. So that's where we want to start.
Okay. I can begin with just a kind of summary of where the city is in terms of its interpretation of the court's order
Mhm.
and how it intends to in our view, satisfy what the court had requested. So I believe, just to clarify again, that as the chairperson has noted, this was remanded for a limited purpose. And that specific purpose, just to quote the order directly, says that the city of Philadelphia shall present evidence to the tax review board to justify the assessed principal costs of abatement/demolition work that had been performed. So in this instance, the city is today going to present further evidence regarding its bidding process, what type of processes must be conducted in terms of a party being capable of bidding for these types of emergency demolitions, that those procedures were followed here. And then also more general, more specific information on the significant number of qualifications that those documents and contracts impose for bidders in this process. And based on that information, as the city has maintained throughout this, under the law, a owner is just period responsible for whatever the amount is that the city paid, assuming it followed its procedures in a bid. Now, more specifically, for the purposes of today's hearing, our view is that the current decision of the tax review board, the existing one, is justified for a few reasons. As was noted, the city conducted and supported by both the finding of the board previously and affirmed by the Court of Common Pleas, the city conducted this demolition on an emergency basis, and it was following a multi-alarm fire. The city, as Mr. Gallagher will testify to, has extensive requirements and checks in place to ensure that only qualified and vetted persons can handle these sensitive emergency demos. Here, those procedures were followed. And I want to emphasize, as part of this consideration, because the evidence that was introduced on the other end is that the board's analysis of the bill here must be tethered, not be tethered to the report that was generated by the appellant's expert, in our view. As the board found at the last hearing, that conclusions of that report were tethered to the cost of the demolition if that demolition had been conducted by the owner. And so I just wanted to help that, note that again for the purposes of framing the conversations today. So in our view, in circumstances where the city responds to an established emergency, it goes to the marketplace that's created by its processes. Those processes were followed, and it solicited bids and went with the lowest, that the cost of that demolition is justified, and that the city's taxpayers should not and cannot be left on the hook to pay for that emergency demolition, despite the fact that all of its processes, all of the city's processes, were followed to the letter. So with that, I will turn to taking testimony from Mr. Gallagher.
I may be heard. May I be heard at this point? This is Vito Canuso, the attorney for petitioner.
You wanted to give an opening, Mr.
Yes,
Canuso?
well, first of all, I object to what the city is going to present, in the sense that the judge, the issue of whether or not the process followed by the city in determining who should demolish was never an issue. The only evidence, or the only basis for the appeal to the judge that heard this case, was that the actual costs were not reasonable. And the judge did not in any way hear any question by us, or was there ever an issue presented in any of the briefs or the oral argument before the court as to whether or not the city followed their procedure. I believe when the judge remanded this case, she was seeking an actual calculation by this board as to whether or not the amount totaling And the amount totaled $69,777 was a reasonable cost for the work that was performed. We never challenged that the procedure followed by the city was inconsistent with what their rules and regulations were. So I would concede, and I have no ability to even question, I'm not prepared to question whether or not the proper procedure was followed. The only issue that was presented to Judge Coyle was the actual cost of $69,077 was not a reasonable, necessary, and appropriate cost for the work that was performed. So I don't want to waste this board's time to hear the city present step by step that they followed their procedure. That's not an issue here. I think the issue is whether or not they can show that the bidder could justify the expense of $69,777 for what had to be done. Now, maybe I'm misinterpreting Judge Coyle's ruling, but that's my interpretation of it. And if they're just going to proceed to present their rules and regulations, and that this Mr. Palmer or P. Palmer Company, whoever the low bidder was met their qualifications, I never challenged that. That was never an issue before the judge, and I don't think we should waste the board's time to hear that.
I appreciate that, Mr. Canuso. Mr. Rulo?
Yes, if I may. So I guess there's a couple of things here. The fact that the processes were followed is one component of what the city is arguing here. What we are introducing.
Are you arguing that as it relates to the cost of the demolition?
Yes, let me actually back up for a second. So Mr. Canuso had used the word reasonable in terms of interpreting the judge's order. The judge's order did not say that the city has to come here and establish that the amount that Pedro Palmer bid was quote unquote reasonable. The issue here is whether or not this, again, just to emphasize that, shall present evidence to a tax review board to justify the assessed principal costs of the abatement and demolition work. The way that the city is doing that is by providing evidence and introducing additional documents and testimony regarding its bid process, regarding all of the qualifications that individuals have to go through to even be in a position to conduct bids. And in our view, looking at all of those different qualifications, which are qualifications and vetting that a normal, when I say normal, I mean another demolition contractor who does not have to do it through the city's emergency demolition program would not have to face. And so in our view, this is explaining in part why there are additional costs faced if you are someone who is trying to do an emergency demolition through the city's program. So in our view, by introducing evidence and walking the board through all of the different vetting and qualifications that any bidder must provide, it helps to justify the cost of the actual demolition. Because we're coming back to the fact again that there were 3 separate bidders in this instance who submitted bids as part of this. And so
I'm going to interrupt you, and it's my recollection is that a lot of that was already on the record from our prior hearing, and that Mr. Canuso is stipulating to the facts that are the facts of what the processes were to get to the bid. So that I think we would ask you to tie it into specific, rather than, I don't know that the board needs you. Mr. Canuso is willing to stipulate to all of those steps as having been followed. The board is familiar with all of those steps from our general experience here. I think what I would ask you to do is take that information. If you want to summarize it, fine, but can you please tie it into how it affects the reasonableness or justifiability of the cost?
okay, yeah, so I think that just to
Mr.
be
Canuso,
clear,
does that go along with some of your objection here, Mr. Canuso?
Yeah, I mean, I would not, I agree with what Madam Chairman has just stated, that if they want to summarize their procedure, but the judge never that
I
was never an
understand.
issue before the judge. The judge didn't question that. I never questioned that. I think the only reason we're here is because the judge didn't think that the $69,777 was ever explained or justified.
But if Mr. Rulo wants to tie in those procedures to the costs, we're going to hear that information.
That is exactly, just to clarify what this is. So one of the documents, actually the key document that the city has now submitted, which we believe ties into explaining the higher cost, is the master demolition contract, which walks through additional qualifications that all bidders must have. And that helps to explain why costs here are higher. And so that is just some of the documents that are being submitted. The other item that I would like to note is that at the reviewing the exhibits that were submitted to the Court of Common Pleas, those did not include all 3 bids that the city received when it actually conducted the curbside bid. So the city today is not going to be providing a step-by-step analysis of each of the line items or conducting a similar analysis to what the a petitioner's expert provided. We are relying on an explanation of all of the different vetting and qualifications through those contracts that a bidder must go through, and then tying that into how that explains the reasonableness, it's not reasonableness because I do not want to use that word, justification of those costs. And so I do think that it will not take very long through the testimony of Mr. Gallagher to walk through these items. I would ask to be allowed to develop that record. And if Mr. Canuso on appeal wants to argue that that testimony should not have been heard under his interpretation of the court's order, then I think that he's welcome to do that. But I don't think that if there's a disagreement as to the interpretation of what the judge wanted from that order, that the city should be denied the opportunity today to at least develop that record.
All right, Mr. Rulo, go ahead.
I just have one other thing to say, if I may, at this point. The 3 bids were clearly admitted and presented to the judge as part of my argument was, part of it was that all 3 bids, the last 3 numbers of the bids were the same number. And so the judge was well aware what the 3 bids were. That is not an issue that the judge was not presented on.
Well, that's not, we weren't there and we're not going to argue about what the judge read or didn't read, but we're going to allow Mr. Rulo to proceed in a summary fashion if he's going to tie it into how it would impact what would be assessed for this demolition. So, Mr. Rulo.
Understood, and thank you. So, and like I said, I think that this should not be a onerous or lengthy, a testimony from Mr. Gallagher. So, with that, I will turn to Mr. Gallagher. And now that you've been sworn, can you just again briefly explain your position and experience with the Department of License and Inspections?
Stephen Gallagher, I'm the Director of Emergency Services. Approximately I have 35 years with the City of Philadelphia, 20 of which have been under contractual services as a supervisor or the manager of the unit.
Okay, and are you so you're familiar with the city's emergency demolition program, correct?
I am.
We will get into more specifics in a minute, but for the purposes of the record, sorry, I didn't know if that was an interruption. I'll repeat that. We will get into the specifics more in a minute, but for the purposes of the record right now, can you provide a brief overview of what that program is?
It's the Master Demolition Program. It's used to abate imminently dangerous and unsafe properties or buildings in the City of Philadelphia.
And how does someone gain the capability to bid for demolitions like that?
It's a procurement contract. They submit, there's an advertisement goes out, they submit to it. They fill out an application to that. Then once that application has been accepted by procurement, it goes through a vetting process. It goes through our department for qualifications, law department, risk management, and through procurement for their processes. So they have all the qualifications, insurances, and equipment to do demolition. And
those are not qualifications and vetting that any contractor would have to go through if they were submitting for applying for a demolition permit, correct?
No, only a demolition contractor can privately or publicly do demolition in the city of Philadelphia.
And you mentioned the master demolition contract. What is that?
Master demolition contract, a city contract that the city put out to do demolition, to hire contractors to do demolition in the city, within the city of Philadelphia for unsafe and dangerous, dangerous and unsafe properties.
And is Pedro Palmer a signatory to one of those master demolition contracts?
He is.
I'm going to, with board's permission, I'm going to share my screen right now. Can you see a document that's been preliminarily marked as City Exhibit 1?
I do.
Okay. And what is this document?
This is the public, it's a summary of the contract, what his contract is, the term of the contract, and his limit to the contract. What is its contract number? It's the
Okay. So I'm not gonna, as the board had requested, I'm not gonna walk through this page by page. But in general, can you summarize for the board some examples of what these additional heightened requirements are for a signatory to one of these contracts?
So in this page, it's a tiered contract. Depending on the contractor's ability to perform, they can do demolitions. Their bond is up to 75, performance bond, either 75,000, 150,000, or $300,000 could be the limit of their bids, or they could have one or two bids equal that total that amount. Then after that, they have to stop.
And each of the bidders in this instance satisfied that highest qualification, highest tier, correct?
Correct.
And I'm going to move down to this document. I'll get the page number in a second. So this is Exhibit B to that document. What is this exhibit?
This is a requirement that any bid over $100,000 that they are required to have a percentage of minority business, minority women business enterprises. They have to meet those requirements.
And in this instance, because Pedro Palmer was had at that highest tier, even though this wasn't a bid of over $100,000, they, because of their existing contract, satisfy and have to abide by that, this requirement, correct?
Correct.
Okay. And can you walk us through kind of, I guess, what some of the requirements of your understanding of the requirements are if you are signatory to one of these economic opportunity plans?
They have to meet, there's a percentage they have to meet of the participation for minority businesses. I believe it's set, the numbers are set by the Office of Economic Development, and these processes are met through their the procurement process of vetting the contract.
And so they have to submit documentation showing their efforts and showing all these things that they have to do as part of that process, correct?
Correct.
And all of these are heightened requirements that a normal contractor would not have to satisfy to conduct a demolition, correct?
Correct.
So these are additional, this is additional items to say that, never mind, I'll withdraw that. Okay, I'm going to move on now. I'm going to remove this from my screen for a second. I want to discuss some more specifics about emergency demolitions. You're familiar with the demolition that occurred at this property, correct?
I am.
And just for the purposes of the record today, and again, I'm going to try and do this as quickly as possible. When a fire occurs, what does L&I's process look like in such an emergency circumstance?
When a fire occurs, we're requested to respond to it by the fire department. In certain instances, the fire department will ask us to hire a contractor to either to assist in a firefighting operation or to insist to make the building safe so they can complete an investigation as to the cause of the fire.
In 1 second.
While you're looking, could I just ask, refresh my recollection, how soon after the fire did the demolition take place?
I believe the next day.
Thank you.
And can you see what's been displayed on the screen as City Exhibit 5?
I do.
And what is this document?
This is the invoice for the fire assist from Pedro Palmer.
So I believe you're familiar with the records here. At the last hearing, this was focused on the demolition, which the chairperson just mentioned. This is a new document that's been presented, and you said it's concerning the fire assist. So in this instance, there was, in addition to a demolition, what you've described as a fire assist occurred here.
Correct.
And that occurred on the day of the fire, correct?
Yes.
So there were now, we have evidence that there were actually two components to what Pedro Palmer did here. They had the fire assist, and then they also had the subsequent demolition that they were awarded, correct?
Correct.
And I
So-
want to move,
Mr. Ruler, are you now saying that this, what is it, $6,100 was folded into the $69,000? Or is
that's,
this
I'm
bill
glad-
that's showing up?
I'm glad that you asked that, because I do want to clarify that this is not an assertion that this $6,100 was part of that, but I believe that it helps to frame the significance of what occurred here, and then as I will get to in a second, if the board gives me some bandwidth, to also connect back to why we think that the bid that Pedro Palmer submitted is justified. So if I could just get a little bit of rope here, I think I
Okay.
could connect it back to that. So I'm going to move down to what's been marked as City Exhibit 6. So these are, Mr. Gallagher, are you familiar with these photographs?
I am.
And these photographs show that Pedro Palmer was actually on site on the day of the fire for that fire assist, correct?
Correct.
I'm going to now move back to what has been, marked as City Exhibit 3. Are you familiar with these documents?
I am.
So if just in summary fashion, this first document is the bid that Pedro Palmer had submitted for $69,777, correct?
Correct.
This next one was from Mangual Demolition, which was for $74,999. And
Correct.
this third one was from USA Environmental for $77,777, correct?
Correct.
And these were all three of the bidders that had submitted bids at on the emergency basis, correct?
Correct.
So Pedro Palmer, because they had been on site the day of the fire as part of that fire assist, in addition to being the lowest bidder, they actually had a significant familiarity with what the conditions were at the time of the fire in evaluating their bid, correct?
Correct.
Okay. 1 second. And then I believe it's been stipulated to, but in this instance, again, all of the city's procedures in terms of vetting these bidders, qualifying them, and then those processes being followed occurred in this instance, correct?
Correct.
And next, just moving to this. So as part of being a qualified bidder in the emergency demolition program, these bidders actually have to be available on a 24-hour basis to even have a capability of responding to these requests. Is that correct?
Yeah, for a curbside bid, yes. For the emergency, yes, they're available 24 hours a day.
So unlike a typical contractor, to be part of this program, they actually have to have employees ready to go on a moment's notice to even have the capacity to do these bids.
Correct.
And in the city's contracts, that's not necessarily accounted for in terms of the cost that may have for one of these bidders, correct?
Correct.
Action.
Cases?
Well, first of all, it's a leading question. Second of all, we have no expert testimony to determine what those costs are. And unless they're going to present such a expert in which they haven't identified or haven't provided me with any information, or it's just Mr. Gallagher, basically Mr. Rulos making the determination that to have 24 hours is additional cost.
Thank you. We're going to note that, Mr. Rule. I hope you're going to tie in a little more detail for the case as you go forward.
Yes, and I'm actually getting close to I think wrapping this up, but I guess first off, just for the purposes of the record and responding to that objection, I think that Mr. Gallagher has testified about his extensive experience in understanding and actually being part of this process for qualifying bidders. He has experience with the demolition program, and I think that the board can take judicial notice of the fact that there are costs associated with having employees available 24/7.
But it's still a very vague assertion.
Understood, and I just putting that on for the record. Excuse me, just one second.
If you're gonna be accurate.
You said the next step. Next, what do you mean by that?
Did we lose Mr. Rulo?
Oh,
Melissa?
yeah, he's
I
coming
don't
back.
see him.
He like just disappeared.
Okay.
Yeah, that's good.
Where'd he go?
Uh,
He was in the waiting room and then
Have we lost them?
We've lost Mr. Rulo, so we're gonna
lost Mr.
moment
Rulo.
try and get him back from.
He jumped back in the waiting room and then
That's
I
what
let
it
him in.
looked like, but I just wasn't sure whether it was my ears or the actual loss.
No, he's gone.
So they didn't pay the bill.
That
It
might be it.
wouldn't be the first time, Mr. Canuso.
I was about to say.
All right, we're gonna take a minute and,
Just wait for him to come back. He is an integral part of this hearing, I would say.
well, yeah, we're not able to proceed.
Excuse me, members of the board, I was just messaged by Mr. Rulo. His computer is logging him in and out, so he's having technical difficulties.
Ah, thank you. All right, let's give him a minute.
Mhm. Hello, Mr. Rulo. Thank you for coming back.
Hi, can you hear me okay?
Yes.
I'm sorry, I apologize. I don't know why it was kicking me off like that.
Glad you found your way back.
Well, fingers crossed I can stay here. And do it on an expedited basis for
Yeah, moving on.
consistent with the board's request. Mr. Gallagher, just returning to that testimony, in the context of an emergency demolition, does the L&I have the capacity to do a thorough assessment of line by line of the different costs of what it will take to do a demolition?
No, it's not a requirement of the contract. The bid is the bid.
And can you explain why, given practical realities, it may not be possible to conduct such a line by line assessment of what it would cost to do a demolition?
There's factors that relate to the cause of a demolition. Proximity of a building next to other buildings. In this case, it had residential properties behind it and in front of it. So what dictates the cost is not just the labor cost or disposal cost or equipment cost, it's the association of it adjacent to other properties.
And so in these situations, to ensure the bidding process goes correctly and that the city obtains the best cost that the taxpayers can, they rely on these contracts. Is that a fair assessment of your summation of your testimony?
It is correct.
Okay. That actually, for the moment, is going to do the finish it for the testimony that I have from I'm going to ask for from Mr. Gallagher.
All right, Mr. Canuso, do you have cross?
Yes, I do. Mr. Gallagher, you said the demolition took place on the next day. What did you mean by that?
The day after so the fire was it happened the following day. The bid.
23rd
Yes,
of October, 2018?
yes.
And by the way, and what evidence do you have of that?
From the documents and.
I'm just going to object right now. I think as Mr. Canuso himself pointed out, the board affirmed when the demolition occurred, and then the court upheld when the demolition occurred, that it was an emergency basis and all of those items. So I'm not sure why, consistent with what Mr. Canuso had said, we're getting back into the issue of when the demolition occurred.
Well, that goes to the cost, I believe, and I want to know, well, I believe that's a proper question. We're determining the cost of this bid and everything else, and I want to know what he said when he said that the demolition took place on the next day.
Well, let's just answer that question and then move on from that inquiry. Mr. Gallagher?
Demolition occurred the following day.
And when did it get complete?
Probably within a week. The exact date, I'm not sure of.
And how do you determine it was a week?
When our inspectors would determine that. We issue a permit for the demolition, it would have a date in the permit when the demolition was
Do
completed.
you have any of those reports as to when it was completed?
I don't have it in front of me.
Well, don't you think that's important to determine whether the cost was reasonable?
Objection, argumentative. That's
Fifth date.
Now, Mr. Gallagher, did you hear Mr. Rullo state that this was a multi-alarm fire?
I did.
Did you review the fire report for this incident?
No,
If I tell you that there was not, the second alarm was just called for a standby, would that be surprising to you?
no, it would not.
Okay, so if the first alarm was utilized for purposes of extinguishing the fire, and the second alarm was a standby alarm, would you consider this a multiple alarm fire?
If it was rung out as a multiple alarm, yes, because a lot of times when they have a multiple alarm, it's either for water or for manpower. In this case, it was a landlocked garage. They needed manpower.
Well, they said it was, but how did,
I'm just going to lodge another objection here. I think the witness has testified that he was not familiar with those fire reports. And again, I think we're getting into, the board has given Mr. Canuso some bandwidth, and we're getting into the issues that were already established and upheld by the court.
Mr. Canuso, can you explain the relevance of this line?
Yeah, because Mr. Rullo made it sound like this was a major fire, multiple alarm fire, when in fact, the fire report only indicates that the additional alarm was only for purposes of standby. Now,
Okay,
Mr. Gallagher doesn't even, he's the expert that they're presenting, didn't even bother to read the fire report. And yet we have to depend on him to determine that this $69,777 bill was a proper and reasonable and necessary bill.
This may resolve the issue, but I will stipulate to whatever is in the fire report. And to the extent that my statement was at all inconsistent with that report, it was an error on my part, an unintended one. And I will stipulate to whatever that document says, rather than what I stated or what any other individual here stated.
All right, let's move on.
Mr. Gallagher, how do you know that the demolition started the next day on the 23rd?
Curbside bids required to start within 2 hours of the bid.
And what other than that's the requirement? I'm talking about this particular incident. What do you have and your basis for your testimony that the demolition started the next day?
We bid it the next day. It was a curbside bid. The curbside bid requires the contractor to start the demolition immediately.
We know what the
I'm just going to object on the basis of
I'm
asking
asking you if you know if that actual happened on this 23rd day of October at 1845 Russell Street, whether the actual demolition started that day?
Objection, asked and answered, and I think that's occurred multiple times. If Mr. Canusa is unsatisfied with the answer, then he's welcome to that, but he's asked this question multiple times.
Agreed. I think Mr. Gallagher's told you what he knows.
Mr. Gallagher, you indicated that one of the factors is the distance of the demolition from nearby residential property. Do you know how close the closest residential property was to this site for demolition?
Not with, only with, I'm estimating it. Do I know the actual measurement? No.
Am I correct that all the residential properties that backed up to this site had a rear yard before there was actually any residence or physical property?
I'm just going to object. I think that this is an extensive characterization of prior evidence that was already testified to. And again, we're getting to issues that were already decided. And I believe that the witness has already answered the question, stating in this last answer that he could not provide a specific number.
Okay, sustained.
Now, I'm going to ask Mr. Rulo to bring up that, and I forget exactly what exhibit. It was the exhibit that was consisted of the 3 bids that were submitted. Could I ask Mr. Rulo to bring those 3 documents up?
Of course. 1 second. And I guess just for the purposes of the record, this is City Exhibit 3. Mr.
Okay.
Canuso, which page would you like me to go to?
Let's go to the first page. And that was that's the successful bid. Am I correct, Mr. Gallagher?
Correct.
And there's on that writing below the signatures on that document. Am I correct?
Yes.
Okay, now let's go to the other 2. And am I correct that below the signature on that, there's no additional writing? Am I correct?
Correct.
And on the 3rd bid, there's no additional writing.
Correct.
Mr. Rulo, could you go back to that first page, the successful bid? Mr. Gallagher, do you know when that writing was put on that bid?
Once the bid was awarded,
And why was that put on?
that's them acknowledging that they won the bid.
Well, how does that acknowledge that they won the bid?
It's part of the process. This is an
Pardon me?
agreement that they have won the bid. They're accepting the bid.
That's the signatures, am I correct?
Correct.
I'm asking you about the writings below the signatures that did not appear on the other 2 bids.
Because the additional specs don't acquire, there are additional specifications. This is what above and beyond the demolition are to remove all debris. They have to remove the rear wall, a 200-foot stone wall, and install 200 feet of 6-foot chain link fence.
So when they made the bid, they didn't even know that that was required?
No, they were told that, and then it was written on this, so these could be added to the permit language, that this was a requirement of the contract.
And how do you know it was told to them?
It's done at every bid. We have additional specifications. There either are or aren't specifications for every demolition that we do in the city of Philadelphia.
So then why is that added on if it's already specified?
Because this is the language that the contractor agreed to. We put it in writing, he signs it. He was told prior to the bid, these are the additional specifications, requirements that you have to do above and beyond the demolition.
And you can't testify as to what actually happened. You're testifying as to what you believe is the procedure normally followed.
This is the procedure. This is what happens.
I'm also just going to object. I believe that Mr. Gallagher is interpreting what is written on this document, which is being submitted as a business record of the city of Philadelphia. The question was about what the writing was on this business.
Is that an
document,
objection to
and
my question, or are you arguing about his answer?
I'm objecting to the question and mischaracterization of what his testimony was in terms of it being as to this document.
I think we understand what's the answer. Let's go on.
Mr. Gallagher, did you have an opportunity to review the submissions by the city of the Burns removal receipts for the debris at the site?
I'm just going to object. I believe that, well, I'll clarify is Mr. Canuso referring to the environmental reports that were initially submitted as part of the environmental asbestos case?
No, I'm asking about Richard S. Burns and Company, Inc. We were supplied with 4 receipts for this property, and they were all for the demolition debris, and they were submitted to Palmer.
Well, they're not in front of Mr. Gallagher at the moment.
I understand they may not be. I'm asking him if he had an opportunity to see them.
I'm not sure how he can ask about an exhibit that he's not presenting to the board right now. So I'd object on that basis.
I didn't ask him if he was presented. I asked him if he saw those documents. They were the documents that the city presented at the first hearing in this matter, and the only documents that show specific costs for the demolition process, other than the bid price of $69,777.
But before we go on, Mr. Gallagher, have you ever seen those documents that Mr. Canuso is referring to?
No, those documents are submitted to our fiscal officers.
All right, then he can't really answer those questions.
And they're not maintained in your file.
I believe he's asked and answered. I'm going to object again, asked and answered. He's asked and answered this question.
He's not familiar with those documents.
How about the Bell Environmental Company report? Are you familiar with that that took place at this?
I'm not familiar with.
I'm going to just first off object because those are documents that are relevant to the environmental bill, which is not the bill before the board. And I just object to relevance of that.
Well, I'll tell you what.
And that they're also not displayed. But again, these weren't exhibits that were submitted for the purposes of today's hearing. They're not exhibits that are before the witness to even competently answer that question, since they're not being presented.
Well, the reason I am asking about it, there's a report as to the Bell Environmental Company as to what they observed on the specific dates that they were there. And they're inconsistent with what Mr. Gallagher has stated today.
I'm just going to object on the basis that now council's testifying as to those documents.
Present those as part of when we move, when Mr. Rulo is finished, because it doesn't sound like Mr. Gallagher has access or is familiar with any of those.
Do you have any documents showing what was done on the 23rd?
Do I have any document? No, I do not have anything in front of me.
Well, did you ever review the file in this matter?
I reviewed the cost. I can tell you about the demolition, the process.
When you said you reviewed the cost, what do you mean by that?
The bid price was $69,000 and some change.
That's the only cost that you examined?
Yes.
So Mr. Gallagher, if I can interrupt a moment, were you ever at the scene?
No, I was not.
You're just talking about the general process, the few documents that you did see, but you are not specifically familiar with this demolition.
Correct.
All right. Well, so Mr. Canuso, I think that might limit what you can expect here.
Was prevailing wage a item of the bid that was presented?
It's a requirement of the contract.
And do you know what the prevailing wage is as of October 23rd, 2018?
I don't have the exact dollar and cents amount of it, but that is also handled through the procurement department, not this department.
Did you have the certification from the Palmer Company that they paid the necessary prevailing wages to their employees for this project?
I do not. That goes to the procurement department. It handles that.
I'm also just going to note this and make an objection to this on the record. It appears that there are conversations happening with the witness that Mr. Canuso intends to present. And specifically, it sounds as though there is some sort of communication that's happening from that witness to Mr. Canuso in the process of this questioning. And I would just object because to the extent that there's questions that Mr. Canuso wants an answer to from his witness, he's welcome to ask that. But this is something that's going on off the record with a witness who's supposed to testify in this matter.
Mr. Canuso can talk to his client, Mr. Rulo.
Well, thank you. Could you give us a minute? Could I put you on mute while I consult with my client?
For a minute.
Thank you. It should be. Thank you. Mr. Gallagher, can you hear me?
Yes, I can.
Good. You indicated on that bid document submitted by Palmer that there was written an item 200 feet of wall. Do you know if there was 200 feet of wall there?
If that's the length of the property, yes.
Well, what did you determine was the length of the property?
I did not determine it. I did not measure it. I was not at the property. I know that they had to take the wall down because it was unsafe.
But you said something about you made an observation or a determination as to the proximity to the relationship of the site to the residence. Am I correct?
I did. I said I could estimate what the.
Okay. And how did you estimate that?
Oh, it looks like it's about 15 to 20 feet.
And what did you look at to make that determination?
Aerial view of the properties.
Okay. And did you, looking at that aerial view, did you measure out 200 feet where that wall would be?
I did not.
Do you know how long the entire property is?
I do not.
Do you know if it exceeds 200 feet?
I do not.
Do you know if the wall was for the entire length of the property?
I did see it, and I would say yes. Whatever the length is, it was from a garage length. I believe there's 6 or 8 garages there. That's what I knew from what I looked at.
Well, if I tell you the fire report indicates there was 14, we believe there may have only been 12. And the average length of a garage is maybe 10 or 12 feet wide. Where would you make a determination that it's 200 feet for that wall?
Garage is probably 12 feet wide and 20 feet deep.
Correct. And so even if it's 14 walls to garages, how would it be 200 feet?
The length of it?
Yeah.
18 times 12.
I'm going to object at this point. I think the witness has testified extensively that he was not at the site. I offered him for the purposes of understanding what the city's procedures, requirements, and that the processes were followed here based on the records in the system. So I think this is going beyond the scope of the direct. The witness has essentially asked and answered that he is unfamiliar with the specifics since he was not at the site. So I think we've said this a couple of times now.
All right, so we're going to take note of that, Mr. Canuso. I don't think Mr. Gallagher can answer your
Very
specific
good.
questions.
Could I ask Mr. Rulo to bring up the document which he identified as exhibit, I forget the number, but it was the bill to the fire for the emergency services. I forget what exhibit number it was. It was the $6,100 bill.
Yes, I can pull that up. Just one
Thank
second.
you.
Pardon, the last time that I messed around with this PDF, it kicked me off, so hopefully I'm staying here. And for the purposes of the record, this is City Exhibit 5, and I'm moving to the first and only page of that exhibit.
Thank you. Now, Mr. Gallagher, did you review this exhibit that you testified to earlier prior to today?
Yes,
Okay, and do you know what time the fire was called to the fire department to
I do not, I do not recollect when the fire was.
And if I tell you it was at get the fire report, and that's previously been submitted to this, that it was at 13:39 hours, that would have been about 1:39, am I correct?
I'm just going to object. The witness has said that he can't answer that question because he doesn't know. And then again, this is testimony about a document that is not up on the screen and been offered today. I don't know how the witness can testify as to that document.
Well, okay, you know how long the firemen and Mr. Palmer was at, and the Palmer Company was at the location as a result of responding to the fire department's request for emergency services?
I don't know how long they were there, but it says they worked for 6 hours if you look at the receipt, the invoice.
And you have no documentation or nothing that you have would indicate that in fact they were there for 6 hours?
Other than the invoice, no. They could have been waiting for 8 hours.
Okay, well, if the fire started at approximately 1:30 in October of 2018, by approximately what time do you believe that it would have gotten dark on that day?
Objection. I think we're back to the same issue. The witness has testified that he doesn't have that knowledge. So I just don't know.
Fair.
Did
And now we're speculating.
you review any of the photographs that were taken and submitted in this matter by the city?
A few.
And were any of them taken with timestamps on it?
I'm going to object again. This is consistent asking about documents that Mr. Canuso has not raised to the witness. The appropriate procedure here is that if he has questions about exhibits that have been submitted here, he can put them on the screen and display them so that the witness can testify as them. I think it's highly prejudicial to continually ask the witness about exhibits that are not actually being displayed at the hearing today.
Well, this is the city's expert. This is the city's person who has all the records. These were the records that were supplied to us by the city of Philadelphia. We didn't create these
Can you
records.
show it to him through the
The
screen?
city hasn't introduced those for the purposes of
Gallagher
today's.
doesn't have the answers, Mr. Canuso.
Okay.
He's not specifically familiar
All
with
right.
the property itself and does not have documents in front of him that haven't been shown already by Mr. Rulo. So there's no point in asking him about documents.
Thank you.
But we understand your position on that.
Can I ask to be put on mute again? 1 second, to consult with my client. Thank you. I have no further questions of this witness.
Thank you. Mr. Rulo, do you have other witnesses or information you want to provide right now?
No,
Want to move your documents into the record?
yes.
All right, so,
I can clarify for the board which specific exhibits the city introduced here, just so that it's a kind of a clear record, if you would like.
sure.
Of course, as I said that, my computer froze. That would be City Exhibit 1. Appreciate patience, 1 second. City Exhibit 2, City Exhibit 3, City Exhibit 5, and City Exhibit 6.
Thank you. Before we turn to Mr. Canuso for his presentation, I need to see if my board members want to step back for a moment to review what we've heard so far.
I would respectfully request a personal break if I can,
All right, so do we want to take 5 minutes?
please.
Thank you. All right, Mr.
Thank
Canuso, then, without objection, we're going to take 5 minutes. The board is going to step back. Mr. Canuso is going to have his break, as will Mr. Rulo.
Thank you.
But except for Mr. Canuso. Okay.
Oops.
Nancy? Clear as day. I don't understand.
I just don't understand.
Okay, I think everyone is back. And off you. Thank you, Mr. Canuso, for taking yourself off mute.
All right, are we ready? Mr. Canuso, you're ready to proceed?
Yes,
Okay, we're going to ask you to please present your witnesses' testimony documents, keeping in mind that, some of it is already in our record from our prior hearing. We're limiting ourselves to the reasonableness, justifiableness of the expenses. And we're going to turn to you.
yes, and I'm going to call as my first witness, Mr. Paul Desser, and I have an up-to-date resume that I have presented to the city. I can leave a copy of that resume here at the office of the board, and
Yes, that would be fine. I think that we have already previously certified him to be an expert in this field, so you don't need to go through.
this is just a more.
We'll take the updated resume or curriculum vitae, whatever it is that he's
Thank
got.
you. Thank you.
Don't add that to our record.
Mr. Rulo, would you want me to present his qualifications again, or can we proceed based on the previous ruling by this board as to Mr. Desser?
I have no objections to his qualifications.
Right, and we hope that you can provide us with new or refreshed information. We don't need to, go back over the entire history. We have.
Mr. Desser, please state your name and your occupation and a brief summary of your experience in the area, is particularly demolition.
My name is Paul Allen Desser. I am a environmental and demolition consultant. I have been from estimating and putting together packages for cities right up to being the CEO of one of the 4 companies that did the cleanup at Ground Zero. I've done disaster recovery in Christchurch, New Zealand, environmental cleanup in Sydney, Australia, demolition in Soweto, South Africa. I've done work here in the city of Philadelphia. Some people know the work we did in the rail yard. It was called the Drexel Shaft. It was the implosion of a 346-foot tower that was 38 feet in diameter that we dropped just short of the main line. We had CSX, Norfolk Southern, Amtrak, and SEPTA in that rail yard. I've just.
Okay, we don't need a whole extensive list.
No,
Mr.
I'm not going to,
Already accepted that you
obvious-
are an expert in this field.
Right, and I'm consistently, even now, doing disaster recovery and demolition projects, particularly ones that are complicated, fire, collapses, etc.
Mr. Desser, would you briefly describe the procedure you followed in preparing to testify in this proceeding?
So what I did was went back through the original documents that have been presented by the city. I went and saw the new documents that have been presented, including the pre-qualifications for Palmer and the bills from the fire department, etc. I was actually looking for something different. I went back and re-examined other documents I had recorded and kept, which were similar buildings that are in the city of Philadelphia, of the building that burnt down. I went and looked.
Objections. These are referring to documents that aren't in evidence or have been introduced now or reviewed. So
Well, he may be introduced. I don't know where we're going with this, Mr. Rulo.
So,
It's just-
I'm referring to all of the prior documents that the city provided, Mr. Canuso. I could give you a list of them if that.
Aren't they, were they in the record previously?
Yes, they were.
They're
I was
part-
just,
And they're part of the board's record since this. is-
Right. And I mean, if you want me to, I can read them right off my computer. I have the file sitting in front of me.
just to clarify, I was just objecting. There were references made to other buildings and demolitions that occurred at those other buildings. And
No, don't, please
Just-
don't. That's not what I said.
No, let him finish and we'll see where we go.
I was asked what I had reviewed, and as part of what I reviewed was the record. And then I also had reviewed the documents I had done to put my expertise and my report together for the board prior to understand the full extent of this structure. I had been asked, was I there when the fire occurred? The answer was no. So I had to reconstruct what was existing. So what I realized was in reading document.
Testifying now as to,
Yes,
as opposed, Mr. Canuso, or is he still going to be just giving his credentials? I don't
No,
know.
this
I
is-
am-
this
this is-
The question was, what did you do in preparation to testify at this proceeding today?
Okay.
so what I did was I actually did things like measure the building. I took the photographs and verified what I had seen. I looked at the timelines that we had created and the city's documentations they had given. For example, the Bell Environmental documentation where there was a narrative. I looked at the city's documents as to how they put together the emergency response, how they pre-qualified people, what requirements are necessary to be able to do this work and what is necessary at the end. A classic example is they are to do certified payrolls, which they are to submit at the end of the job. They are to do, as the other gentleman referenced, providing minority participation, best effort, and what they actually did. They are to provide any permits or anything else that was done for it. So I went through all of this to validate whatever I could, so I wouldn't say something here that I could not swear and attest to.
Now, proceeding, what was your observations as to the extent of the demolition that was required for this particular project?
Okay, so the first thing I did was I looked at the fire department records that the city has provided. The fire department recorded that they arrived at a specific time. They were on the site for 116 minutes. That Palmer was called onto the site. Palmer did work. There were photographs that were presented showing the work with the fire department there and the work they did on the 22nd.
What were you able to determine as to what had to be done following the 22nd of October 2018?
So unfortunately, because we're sitting in a room without the ability to push things up on a screen, can I ask your indulgence to physically hold up some photographs?
We won't see that. Miss Andre, if you could grab that.
Wait, you can't see us?
I can see you, but we won't be able to see the
Can you
document.
see that?
No. I mean,
Oh,
we can see that you're holding up a document, but we really,
okay, these,
yeah, so
so
hold
let me
on a
just,
second.
oh,
Our executive director will come and get from you.
these are all the city's documents, by the way. No, I know. But I just wanted them to know they're not stuff we,
Were these, Mr. Canuso, are these documents previously admitted
They were here,
prior hearing?
they were presented at the prior hearing.
All right, then we do have them. We just don't have them in front of us at the moment.
Matter of fact, there was 2 dates of hearings in this,
Yes.
matter, not just one.
But I wasn't sure if he was providing new documents or
no,
documents
no.
he's seen. Okay.
Do you want me to continue while she's doing that?
Please.
I don't want to waste your time.
Yes, please do.
So the building was 18 feet in depth. It was 161 feet or 166 feet long. Why was that important? Because we were trying to calculate out what the quantity of material that was taken out, what the cost should or could have been, what they actually did do, because my goal from reading the judge's office order was to come up with trying to figure out whether there was reasonableness. And this went back to rereading the documents that Michael put into, or Mr. Rulo put into evidence about the process. And I've done many of the, what they call corner bidding. So what happens is when they do this, 3 people go, you get 3 contractors who are pre-qualified come in. They each get told the scope, they look at the job, and then they are allowed to go, so to speak, to their own corner, fill it out, hand it in, and whoever's low bid gets chosen.
I'm going to object at this point as to narrative and non-responsive. I think I've given some bandwidth here, but there is a question, and I think there's been testimony now for an extensive period of time that's also included apparently analysis of what the court's order meant and this witness's
Okay.
interpretation, who's not an attorney. So
No, I apologize. It was what Mr. Canuso asked me to do.
Okay.
I apologize. I am not interpreting the court's order. So in looking at it, I went back and of course, since Mr. Rullo had presented other additional information about Palmer, I examined both their qualifications and as well as the process. In looking at this, trying to understand costs, one of the issues was reasonableness. So if one contractor said the job was $1 million, the second contractor said 2 million, and the third contractor said 3 million, it's incumbent to look at it and say, is that
objection, this is essentially a question being asked that hasn't been asked and is now being answered. And
no.
I can't even object. I need to at least put this on the record, sir. It's essentially he's asking a question and then answering his question at the same time. And that question hasn't actually been asked. And in this instance, if he's talking about a hypothetical with millions of dollars, I need to be able to object to that on the basis of it not being relevant because it's a hypothetical that isn't before the board right now. So
Right,
I'm trying to phrase this, but right now it's just respectfully, sir, and you are eminently qualified. This is kind of just rambling on in a narrative fashion rather than answering any question, which compromises my ability to make objections. So I just need to note this for the record. To the extent that the board is going to proceed in a specific way, I default to them, obviously.
All right, so noted.
Well, I'm asking you, did you observe or did you review the documents that were presented by the city through me, which consists of the procedures and which are consistent with the exhibits that were submitted by the city today, which consists of exhibits number 1, 2, I believe 3. I have them written down here someplace.
Yeah, it was 1, 2, 3.
And there was 5 and 6, I believe. Did you review those documents in preparation for the testimony here today?
Yes, I
And
did.
what observations did you make as to the determination of whether the cost for this project was reasonable?
So what I did was I looked at your procedures, which it appears were followed correctly to the point of submitting bids. It was then the question of when you award it, do you just award it simply because, and I tried in delving in what you presented, Mr. Pullo, in delving into that, it was not clear to me that if it is an unreasonable, do you still award it? So I was asked by the client to say, is this?
Well, Mr. Canuso, are you asking the question?
Yeah, I was asked, what was your determination as to the bid that was accepted as to whether or not it was reasonable?
And I just have to, and I understand the board's going to proceed, but I just need for the record to object. This is calling for a narrative. It's not and that is why the witness is kind of, going on about its entire process. And then the second thing here is that the question of whether or not the costs are being justified, that was a legal requirement that preserving all of the city's objections for a variety of reasons, that it appears that the legal question is trying to be answered here. If there are specific facts that would be requested that Mr. Canuso then wants to use as a basis for his legal argument, I think that's another thing. But I'm just going to object on this being narrative, non-responsive at this point.
Okay. Mr. Canuso?
I think the question is proper and he's the expert and I want him to make a determination that.
All right, well, I guess what we'd like is more question and pointed answers and not, a lot of the extraneous information, perhaps.
Has anything that you've heard today determined that the city in any way made a determination that the low bid in this process was reasonable?
No, I have not heard anything so far presented today that has said this bid was reasonable.
And did you make a determination as to what what documents did you see that were specifically helpful in you making that determination?
Sorry. The photographs that were presented, the information on Palmer and the way they build the original fire response, the fire department information, the Bell environmental narrative of each day they were on the site, that Palmer was supposedly on the site as well.
And what did the Bell, what did you observe as a result of reviewing the Bell environmental narratives?
I'm also just going to object. I believe the board has already concluded that those documents are beyond the scope of today's hearing because they were relevant to the other case, not the one that's before the court here. And I'm just going to, I will say this for the last time, hopefully, but I'm just going to object to this continued questioning of asking the witness to make a determination of whether or not the bill was reasonable in this general fashion based off of it. I think it's calling for the witness to make a legal conclusion, which the court had asked the board to make. If there wants to be specific questions that then allows Mr. Canuso to make an argument to persuade the board that this was not reasonable, that's one thing. But just a blanket question of was this reasonable, I'm just going to object, make that a standing objection at this point.
I'm asking him what did he observe as a result of reviewing those Bell reports that assisted him in making. He already made the determination that the bid of $67,777 was not reasonable. He already made that determination. Now I'm asking him specifically what he looked at and what those observations were of those items that resulted in that conclusion.
All right, but Mr. Canuso, the Bell reports were prior to the demolition, correct?
No.
They're concurrent with the demolition?
Yes.
All right,
I
so,
do want to point out that they were for the asbestos.
right, and those are not under review.
Yeah, but what I'm saying is that, well,
I guess we want to know.
Let Mr. Desser.
Can I just explain it in the simple?
Could you succinctly?
I am. The Bell reports are the only narrative of the job of who was there, when they were there, when they performed work. If you follow the Bell's narrative, the fire occurred on the 22nd on Monday. Bell showed up on the 23rd to do sampling, and they also did the curbside bids. The no work occurred on the 24th. So the 3-hour thing did not occur as far as I can determine anywhere. Then on the 25th, according to the Bell narrative and everything I've been able to determine, which is one of the reasons I keep asking for the prevailing wage sheets, is that was the first day they arrived, meaning Bell, because the inspector had been on site, sampled, and they were not going to do any work till he determined if there was asbestos or not.
I need to object again. This is testifying as to the content of documents which speak for themselves, which the board has already said are not present today. And again, I think that the way that this is proceeding is prejudicial because it's just a narrative rather than specific questions that can be evaluated in the city object to. I'm trying to be as respectful as possible, but I just think the manner in which this is proceeding is not proper.
I guess what we'd like is a little bit more specifics, Mr. Canuso, as to what your expert believes the reasonable or justifiable bill should have been or could have been.
Did you review the bills from the Richard Burns company that represented by the city were the cost for the removal of the debris?
Yes, I did. There were 4 waste manifests that were provided, or hauling manifests that were provided.
And what were the dates of each of those documents?
The one was on 10/25, second one was on 10/25, third one was on 10/25, and fourth one was on 10/26.
And were there any bills submitted for the removal of debris on the 23rd or 24th of October 2018?
Not from the city to anybody that we have been able to acquire.
And after you reviewed those bills, what did you determine was the amount of debris that was removed based on those 4 invoices?
There was a total of 17,360 pounds, which is 8.6 tons. That came to $681.20 of tipping cost or transport and disposal cost for that fire, for that job.
And what if anything have you calculated to be what would be the related cost for the labor and equipment necessary to have that amount of debris from the site removed by the contractor?
I need to step in and object here again. I've just reviewed the certified record that was submitted on appeal here, and I can't even determine what document, these Burns documents, are being referred to. And again, I'm really not trying to be difficult here, but it's almost impossible for the city to respond here if they're being referenced to documents that are not being displayed, that I can't even identify by an exhibit number right now.
They weren't submitted at the prior hearing. We do have them in our record from our prior hearing, Mr. Rullo,
Yeah.
It is,
but I don't have them in front of me.
You want to? I don't know. You can't, again, you can't read these, correct?
Ms. Andre, do
No,
we
no.
have those in our
We have,
file?
we have
Yeah, they
extra, we have extra copies here. These are the four invoices that the city supplied at the previous hearings.
I remember them as well. They are, one second, I'm looking through the city's bigger.
I have extra copies here, but Ms.
All right, hang on.
Okay, I'll come and get them.
yeah, I'm not trying to be difficult here, but it's just, I need to have an understanding of, and not disputing whether or not those, but they're not on the screen. So I think that these questions need to be tethered to the documents being on the screen and questions being asked on them, both for the board's purpose and then for the city's purpose.
Can I answer the question I was asked?
One moment. I think Ms. Andre is going to come in and get copies of your documents.
So I'm going to email it to you, but if it helps, it was actually part of the petitioner's packet of evidence. They had submitted a request for a right to know, and it was part of what the city had provided to the petitioner on August 16th of 2018 when they requested a right to know.
But we did see them at our prior hearing, I remember,
Absolutely, yes, they were definitely part of Mr.
part of the record.
Canuso's record. And if I'm not mistaken, I'm looking at the city's exhibit packet, and it looks like it's in Exhibit R. And if not, then it is
From the prior hearing?
from the prior hearings, from the,
Exhibit R.
no, they're specifically in the petitioner's exhibits that were submitted at the time of the hearing. So if you go to the petitioner's exhibits, they were that the tax review board submitted as part of its record, it's number 4. But I'll also send you the scan that I just sent over.
Great.
Yes, and I apologize. I guess I would just, note for the record, I'm looking at the court's docket for this matter and the certified record that was submitted, and I don't see that. So I'm not, disputing whether or not that was entered by at the last one of the hearings, but it's not part of what was submitted on appeal to the Court of Common Pleas. So that would appear to be something that would need to be resolved if this was to go back up. I don't know why that occurred. I just wanted to note that because it's an administrative thing. Apologies for any confusion I've created on that point.
So then let's move on. Mr. Canuso.
what other observations did you make as a result of reviewing those 4 invoices?
With a total of $681.20 to load 4 dumpsters with a mini excavator, which they had on site, a 304C Caterpillar. It should take no more than 2 days if you were doing it, I'm not going to be derogatory, but very slowly. We don't know, except from the Bell environmental narratives, how many days they actually were on site there, how long they took. We only have what information, or I only have what information Mr. Canuso got through his Freedom of Information Act, or whatever it's technically called. In doing that, I looked at then the calculations of what had been presented by the city of Mr. Palmer's construction 935A bill, and looked at that and tried to match up that to the fire department bill, the fire department narratives, and the rest of the narratives. Fire department said they were there for 116 minutes. The bill from Palmer, that 935A, shows 6 hours. The equipment was brought in on a truck. They have a dump truck for a thing, and then they have transport of excavation, which appeared to me almost like a double bill. But I'm just trying to look at this and come up with what was reasonable and what made sense and how they bill or count items. I found it to be, even at a prevailing wage rate, I'm going to be blunt. Their invoices, their billing, and the numbers don't make sense, because prevailing wage is a very basic item that gives you the wage and the benefits for a worker. And the wage and the benefits for the worker in this case, in the Palmer bill that we're talking about, was, I apologize, I don't have it exactly in front of me, but it was approximately $66 and change.
I'm sorry, what was that again?
$66 and change. I actually have it written down that I could, and if you start doing the numbers and you look at their bill that they have, you would find that it just, even at the lowest worker, I want to change that slightly. The $66.66 an hour is what they in essence charge for the 6 hours they were on site. Each labor, they said, was $400. I can't back it into the prevailing wage with workers' comp, with taxes, with Social Security, etc. And that's why workers' comp in a city job is so important, because it is a certification that the workers actually got paid that amount. And that would then tie back to, if you only had, using the cases, I believe, 4 workers for 2 days, you can't get above $25,000 for this whole job, with equipment, with everything, even paying prevailing wage. So I'm stepping away from the fact that this happened. And I just struggle, I'm being honest. As an expert, I struggle with the fact of an emergency work that didn't start for 3 days after the fire. And if you look at the pictures I asked to have available for the board, are those pictures available to be shown?
I think, Mr. Rowley, you had photos attached to your.
No, these are the ones.
Where we just presented to.
I emailed them to Mr. Rulo, and if Mr. Rulo can pull them up,
Oh, okay.
that would be great.
Mr. Rulo, I think there are just 3, if I'm correct.
One second.
Yep.
Board's indulgence, as they say, please. These city laptops don't move the fastest.
So I think, Mr. Dessler, this is consistent with your prior testimony. I think we even have a document that your assessment is that a reasonable figure that would represent a demolition of this kind is in the $25,000 range. Is that correct?
Correct. And it's backed up by some of these, the new information that was provided of what they did tied in with the photographs. It's kind of hard when you're examining something if you have disparate parts that you can't put together until later on. And this new Palmer document about the fire that the city provided and the photographs that they had provided earlier that I'm waiting for Mr. Palmer to be able to load that were dated 10/22/2018 at 6 o'clock shows the site after the fire was out, after the fire department was done, because they had Palmer there to make sure according to their records, which you have, to make sure that all the fire was out and there was no hot spots. It shows the wall still standing. There's testimony that the experts, quote unquote, said about the structure that just don't match reality. Both the size, the dimensions, the length, the width, the height of the wall, what it was made out of, how much material would have come off. I look at this and I just honestly.
This is not an objection necessarily, but if I could, I'm trying to bring up the petitioner's petitioner's exhibits for them. So I'm trying to do two things
No,
at once.
All
And
right, well,
can't-
let's
I got
take
it.
a
Don't
minute
worry.
then. Let's pause for a minute.
Sure.
Pardon, this is just not loading for me at the moment. I am genuinely trying to pull this up.
So can I end this for you, East?
Okay.
Let him get the.
Okay,
Let him get the photos.
Sure.
All right, well, maybe this isn't gonna.
There you go.
I believe it's being displayed. The only thing that I would just note is I don't, and Miss Andre, you are amazing, and I appreciate you sending this over. I would just note that I think it's a little bit difficult because we don't have the exhibit number for this up on the screen for the purposes of kind of recording this. And then, due respect, I'm just going to object to the city having to be the ones to present these witnesses on behalf of the petitioner here, just for the purposes of the record. I just want to note that.
Well,
It does appear that this is the document that was referenced and is now up on the screen. I just don't have an exhibit to present. Are these the pictures that you had mentioned?
Yes, sir.
Okay, so what would you like to tell us about these?
So
photos?
if you slide down, the first photo just shows that it's the 304C. It's a Caterpillar. It's a small excavator, and this is while the fire was still there.
On the left. Okay.
Yeah, and that the fire is still there. The second picture shows the fire is out. Same machine is still there. The wall is still up. The wall is not being held up by the roof. The roof was being held up by the wall, which is what the documents were saying. And there was no, in any estimation, an imminent danger of collapse because.
Objection. The court already confirmed that this was an imminent danger. That has been decided. That is not the issue before. So to the extent any of this is based on this not being an imminent danger, we object.
So my point was that based upon a decision made that the court made, which I would disagree with, but I understand that the court made that decision, we had requested all the documents to be able to put the narrative together, to be able to give you 100% accurate information. Because the pictures now tying in with that 935A document, I think it's maybe A or 1 or 2, A or B, whatever of the newest that were presented. The bill from the same people for the firework, okay, you would find that none of this fits together anymore. And it makes it very clear that if in 2 hours all that work was done, 2 days to clean up the rest of it is not at all unreasonable. And having waited, not following their own procedures, meaning the city starting work within 3 hours. I always thought it was 2 hours, but 3 hours after the curbside. that if they don't start till the 25th, they even violated their own rules.
I'm just gonna object again. I think
I
we
don't think
moved from
we know yet.
testimony into the witness is arguing, and I think that this has happened substantially right now. If the witness is standing by the previously submitted expert report, that's one thing, but we've gone into the witness just arguing this case.
But he's offering an opinion, which as an expert, he's entitled to do, but some of this is still just opinion.
Right. And I will say, thank you very much. I will say that part of it is looking at pieces that have come in the past week or two, makes you go back and reevaluate. And the reality is taking the new documents with the old photographs, with the bills, I'm even a stronger opinion that it was not a reasonable cost for this project. And that this, based upon the information provided, was a down, dirty, quick, no foundation, slab on grade. Even if you're taking the wall because you're arguing it needs to go, it is not, in my professional opinion, anything like reasonable as to what the Palmer wrote down on their document, and whomever makes that decision to award raises the question of, was it reasonable?
Okay,
Mr.
we have that. Mr. Caruso, do you have any further questions?
Yes, Mr. Desser, were there any mechanical systems in this structure that was demolished and removed from the property?
No, there was no electric, no water, no gas,
And was there a basement?
no basement.
Was there any type of material that required unusual or additional expense or procedure to demolish and remove from the property?
No, quite the opposite. There is what's called scrap value for this work. There was all of the metal that you can see in the photographs shows that was not disposed of. It doesn't show in any waste disposal, which means it probably went to a scrap yard and the contractor would have collected additional revenue.
That's spec.
Objection, speculation.
Agreed. I'm just saying it's gone. We have no idea.
That's
where it
all.
went.
Mr. Desser, did you make a determination as to the length of the wall that had to be removed as a result of this fire?
166 feet long.
And at what did you determine would be the weight of such a demolished wall that was 2,200 feet long or 166 foot long?
166 feet by approximately 8 foot tall by approximately 1 foot thick of concrete, brick, etc., would be 1,328 square feet or 49 cubic yards. The standard for concrete or brick is roughly 1.8 tons per cubic yard, which means that there would be 88 tons of brick debris alone going out.
Were you provided, or did the city provide any evidence of the removal of debris of that size at this project?
Nope, that's part of the dilemma. The 4 waste manifests simply show 17,000 and change pounds, which is 8.6 or 10% of what we would anticipate the weight going out of just the brick would be.
Now, Mr. Desser, you indicated that you reviewed the requirements for a demolition contractor under these circumstances as provided by the city in exhibits 1, 2, and 3, I believe. What did you determine as to the requirements for purposes of verifying that the prevailing wage was provided?
By law, it's both federal and city and state. There's supposed to be certifications under penalty of I believe it's perjury and of.
Objection, this is
I
calling
don't
for a
know
legal
what it is
conclusion
exactly.
now.
No,
Okay, well,
there's a
and this-
bottom, at the bottom.
I'm sorry,
Hold
I'm
on,
sorry,
hold on,
I'm
Mr.
sorry, I'm sorry, I'm sorry, I'm sorry, I'm sorry. I have to jump in. If the city's attorney is raising an objection, please let the attorney respond. The witness should not be responding to a city's
Right.
objection. You've
Got
done
it.
multiple
Right.
times, but I needed to let you know.
Thank you. Mr. Rulo, do you have anything more you wanted to say about that? I'm going to ask that last statement be stricken from the record.
That would be my next request as well, so assuming it was sustained.
Mr. Desser, what physically was required of under the requirements presented by the city for the procedure and under these circumstances, as to what documents the contractor was required to present at the conclusion of the work?
The minimum is a certified payroll showing the number of workers, the day they work, their social security number, their name and address, and their pay and a check number.
Did the
I'm just
city,
going to object for the purposes of the record. The document speaks for itself.
What the?
okay,
The prevailing wage.
and was any of that information supplied to us by the city in this process in trying to provide a reasonable determination as to the cost of this project?
No,
Did you make a determination as to who was the city Department of L&I inspector that was on the assignment for this project?
no, only the initial individual who did the bidding.
Well, and who's that individual?
I forget his name off the top of my
And
head.
that was not Mr. Gallagher, am I
No.
correct?
Absolutely not.
And he hasn't been presented today to present his observations and testimony as to the process that was followed by the low bidder. Am I correct, sir?
Correct.
I have no further questions of this witness.
Okay, Mr. Rulo?
If we could just very briefly take a 2-minute recess, I'm trying to assess some of these documents that have been mentioned so that I can cross-examine the witness. I believe any cross-examination should take 5 minutes, maybe 10, if that.
And Mr. Canuso, do you have additional witnesses after that, or
No.
we wrap up?
No.
Okay, so we're gonna take a 2-minute break.
That should be
Thank you.
sufficient. Thank you.
Okay.
Thank you.
We're gonna go off the record. Mr. Rulo, are we ready?
I'm ready.
Okay, can we call everybody back? We're gonna go back into session.
It looks like
Rulo?
Mr. Canuso stepped away. Oh, there he is. Okay.
Okay, we're coming back into session. Mr. Rulo, we're gonna turn to you.
Believe the petitioner is still muted, so I just wanted to give them a second. Chairperson, do we need to wait for board member Cremedine to?
Yeah,
Oh, did we lose Nancy?
yes.
Oh, wait, I'm sorry. I just said, I didn't realize her room is still there, but she's not in it.
Yeah.
Hang on.
So can you press, unmute? Can you unmute yourself, Mr. Canuso? Can you guys hear me?
I can hear you.
Thanks.
We can hear you, Melissa.
Okay, thank you, Mr. Canuso.
Thank you.
All right, we're just waiting for
Nancy to come back.
board member. I don't even see Dylan, her dog.
But I bet
usually-
he followed her.
Yeah, he's usually on the chair behind her.
You can sit in.
I know.
Okay, Nancy, we're back.
Okay, sorry.
Okay, all right, Mr. Rulo?
Yes, thank you. Pardon. It's getting late in the day. This has been one. My first question was just going to be, and thank you for appearing here today. Were you there at the time of the fire?
No, sir.
Were you there during the subsequent days?
No, sir.
When was the first time that you were at the property?
I forget the exact date, but I believe it was sometime in January 2019.
And and pardon if I misheard your testimony, but I believe you had testified regarding a bit, am I correct that you testified a bit regarding the stone wall that was at the rear of the property?
Yes, sir.
And if I heard you correctly, you'd estimated that there was many tons of stone that would have been removed as part of that. Is that correct?
That is correct.
And if I heard you correctly, it was that the city had failed to provide any evidence. What you'd said is, I believe, paraphrasing it, is that the city failed to provide evidence that that wall was actually removed as part of the demolition. Is that a fair assessment of your testimony?
No, sir.
Could you, I guess, re-explain that? I thought I had heard you say that the city failed to present evidence on that point.
No, what the city did was the city provided photographic evidence, and the physical state of the site shows the wall was removed. The documents the city provided only showed 8.1 tons of debris going off the site. The wall, because of its length, width, and height and thickness, okay, would be 10 times that amount of debris unless they used it in some other manner off-site.
But you're not disputing that the wall is not at the property anymore?
No, I'm not at all. Of course it's there. I showed you pictures, or there are pictures, dozens of them the city provided after the fact.
And are you aware of whether or not the petitioner ever demolished the wall?
Petitioner did not. I am aware of the petitioner being ill. No, yes, I'm aware she did not.
Okay, so in the documents that were mentioned earlier that the city had introduced, the demolition of that wall was specifically included.
Yes, sir.
And the photos show that the wall is no longer there.
That is correct.
That does it for my questions on that point. If you could just quick indulgence. That does it for my questions for this witness.
Okay. Mr. Canuso,
What-
any other
Brief-
information?
Briefly, the size of the wall the city indicated existed prior to demolition was how long?
200 feet.
And your observations, your examinations, your review of this matter determined how long was the wall?
166 feet.
Now, these inconsistencies in the information provided by the city in determining whether or not this cost was reasonable, is that a factor in your determining your opinion?
Yes.
Thank you. I have no further questions.
No further, and no further witnesses.
No,
Okay, so before we get to we ask you each to do a brief closing. I have a question for Mr. Gallagher, having listened to Mr. Canuso's case. If Mr. Gallagher, you still there?
Yes, I am.
Okay, could you turn your camera on?
Yes, ma'am.
I have a question about the city's expectations and requirements following this kind of an emergency bid demolition. What documents are required of the contractor to provide the city once everything is complete?
So when a building's demolished, the wood material that cannot be used as clean fill has to be documented to where it's disposed of. So the 4 tickets compire of the roof, any framing material, any non-clean fill, which would be the brick could be taken from, recycled by the contractor and taken to use to fill at his, whatever he chooses to do. We
Okay.
do not need a receipt for that.
Any documentation regarding the Prevailing Wage Act, number of workers, hourly rates, who got paid, how many trucks, how many people, how many anything?
The requirement for prevailing wage is a state requirement that's in the contract, that the contractor is required to submit to our procurement department after the demolition that he paid his employees a prevailing wage.
Okay. But nothing else to L&I?
No.
Okay, that was my only question. Okay, Mr. Rulo, do you have a brief closing?
Yes, I do. Just one quick second, please. I appreciate the board's indulgence as I experience these technology challenges today.
We've all been there.
I feel like all of us have had those, particularly in this case, and I don't know why, but it's just one of those. So thank you. I will be brief now. So the city's position in this case is that under section 110.6 of the Philadelphia Code, the language for when one of these demolitions occurs is that the owner these costs, quote, shall be charged to the owner. There's nothing in this language, nor have there been any cases cited that requires the city to conduct, as I believe that, and pardon if I'm mischaracterizing it, Mr. Canuso is interpreting the court's order, that the city must provide some sort of a market analysis that is done in this emergency context to do an assessment of a bid before it can accept it and then proceed in these emergency circumstances. The city's position is that it has a process where individuals who want to conduct, be part of this master demo program must meet thorough and extensive qualifications, both under state law and then as is reflected in that master demo contract. That those qualifications are meant to ensure that they are competent and follow all of these procedures so that they can participate in that program. Here, that created a marketplace of bidders who satisfy those different requirements. And as Mr. Gallagher had testified, those range from minority business and women business requirements to, and I'll just incorporate that entire document with all of its other qualifications and requirements into the record now. I believe it's already admitted, but just want to note that. And here, all of those procedures were followed. There were 3 bidders who satisfy all of that. Each of them came in. One was that ranged from 80,000 to, I believe that the winning bid, as discussed, was around 69,000. And the city went with the lowest bid. It followed its procedures to the T here. And in this instance, as has been noted extensively, this is an emergency matter. And if the conclusion of the board in interpreting that decision from the court is that the city to have an ability to recover its costs for a demolition so that taxpayers can be reimbursed, is now that in an emergency context, it must actually stop and then have someone conduct effectively a market analysis line by line of what the cost of each of these items should be. I don't know how the city can proceed in that context with emergency demolitions, knowing that it has an option to actually recover the taxpayers' costs for conducting that emergency. And, you know, what I would also just kind of note, and you know, with due respect, is that a lot of what has been said in the expert report is focused on what this should have cost and I believe that the board noted this in its findings, if the owner could proceed as private citizen with this demolition. And the reality here is that, as the board's findings of fact note, the owner was at the site on the night of the fire. This was an emergency situation and did not return to the property for 3 days. So the city had no other option here but to proceed with an emergency demolition based on the bids that it received from three highly qualified contractors. And, in this instance, the taxpayers are entitled to be reimbursed here. So, on that basis, we'd say that the costs are justified based on all the documents we presented today, along with the established record.
Thank you. Mr. Canuso?
Thank you. I don't believe the city has provided all the records they have. Mr. Gallagher repeatedly referred to the procurement department receives those documents. It is my determination, and it's my argument that this board has an obligation to this court, that the court be provided with accurate documents and sufficient documents to justify the cost. I think there was no showing by the city that the costs were reasonable and necessary and consistent with market price. The court never had to consider whether or not the procedure that they followed prior to up to the bid was proper. We never questioned that. We never thought that that's not the procedure that the city followed. However, now that the court has asked this board to make a determination as to whether the costs were reasonable, they have failed to provide, like Mr. Gallagher said, that there were requirements that a prevailing wage certification had to be submitted. Why wasn't the actual inspector on the job presented to testify as to what days the work was performed? We have evidence that it was not performed on days that the supervisor or the chief who testified today made a determination based on his records, not a complete and actual observation as to the actual occurrence on this particular project. The fact that there was supposed to be daily reports by the L&I, where are those reports to show what was done on each and every day allegedly by the contractor? I think the city has failed to present to this board what has been requested by the court, so that this board can make an accurate determination as to whether or not the costs for this project were proper, and that the court should conclude should be the obligation of the petitioner in this situation. Thank you very much.
Thank you. At this point, we are going to close the record. The board is going to take this matter under advisement so that we can take the time to review all of the documents that have been discussed today and have a conversation regarding the testimony as well as those documents. So you're going to need to give us a little bit of time, and you will be notified at such time as we have a decision to render.
Thank you.
Thank you. If I may, one quick administrative item.
Surely.
My intent was to resubmit that Exhibit K, and I believe there were some others that were mentioned, because as I noted, and this just appears to have been an administrative error. There's some of these documents do not appear on the court's docket of the certified record. So I think that this was I know that this was bifurcated, and there were some issues there that I think are origin of that, but it does appear that the court did not have some of the documents that had been introduced at the last hearing. So I'm not sure how we can, as a team here, address that, but I just did want to note that that appears to have been an issue. For now,
Can you submit to us a short memo as to which documents or which exhibits you're talking about? Copy Mr. Canuso?
Well, I would respectfully suggest that all the exhibits that were at the previous hearings be submitted to the court. I did not make that observation in reviewing the record that was submitted to the court.
Because I don't know which ones are missing.
And let's send everything.
Perhaps the best way would be maybe for Mr. Canuso and I to confer to review what is on the docket and what we believe was presented at the last hearing. And then if I am wrong and all of those are up there, then I am happy to say that I was wrong. And if I am right, then we can confer and submit that to the.
Absolutely, or
Listen.
you could just submit it to me and then I can upload it to the record.
Oh,
Like I said, I felt like we had submitted
We
everything.
thought we
Well,
did.
well,
I am happy to be wrong here. And Miss Andre, you are usually so
Yeah.
on top of this that it is embarrassing for me to even mention this. So
But
if
let's-
I am wrong, I will gladly eat my words.
let's err on the side of duplication of everything. Present to the court everything that should have been, if whether it was or not, so the court has it again when they're making this final decision they have to make.
Well, at this point, it would have to be appealed again to this, to
Yeah.
the Court of Common Pleas. They're not reviewing it at this point. I guess what we want to make sure is that we have everything.
Correct. I just wanted to clarify that. I didn't mean to cause trouble. I figured I was picking up on these. If I'm wrong, I'm wrong, and I will eat my words and apologize to Miss Andre. But we will confer, and if there are any missing, submit them to Miss Andre.
Fine, I think that'll work. That being said, that concludes our business for today. Thank you all very much and have a good evening.
Thank you.
Thank you. Bye now.
Bye-bye.
Well, do we have to concur? There is.
It's under advisement. We don't need a concurrence.
Okay.
We're good. So so we're gonna talk on Thursday.
Yes, we're gonna,
And-
it won't be very long. I'll send another link, and I'll send actually the recording, this recording, so we can all review. and
Great.
then, you know, we can make.
And we have the additional documents in our emails as well as the things that were submitted prior.
Exactly.
And,
All right.
and I'll see if I can do anything about hearing things, but I'd also appreciate it if Melissa would see about that.
New mic,
um,
will do.
um,
I'll order a new mic.
Speaker at your end.
Okay.
All right.
everyone.
Bye, everybody.